That was a great case.
All right, we have the Buhler versus Buhler case last.
Buhler.
On the docket, Mr. Yardley.
Buhler.
That's right, Buhler.
Morning, sir.
How are you, sir?
There's a phrase. The law is that which is boldly asserted and plausibly maintained.
Well, thank you for your argument.
What does that mean?
It means if you say something, it doesn't really matter if it's the law. If you just come right out and say, the law is you can't modify child support beyond the day that the petition was filed, and you just boldly say that's what the law is, and then you plausibly maintain it, that you can talk somebody into your position.
So kind of like Fox News is what you're saying.
It's exactly what I'm saying.
Okay.
And Aaron Burr, who said that, he was a bad guy.
But this was Silvernail, and experience has taught us he can be talked into anything.
Because I think it's because of his experience that
It's
he
the
missed
last
it.
one that talks to him that, kind of.
The general rule is
Who had the
that
last
you
word?
can't adjust child support beyond the filing of the petition. And because he has such vast experience in the family law, that he forgot.
He was wrong though, wasn't he?
Well, that's the point I'm trying to make.
We had already said that, right?
Yeah.
What happened is, this court, well, that's my third issue, but what he should have done is, instead of listening to my more skillful opponent in the trial court's bold assertion that you can't modify child
It should
support.
go back when the father stopped exercising his visitation.
That's exactly what the statute says, and the reason for that is that the legislature has given.
So you should have won.
I should have.
Did you tell the judge that was the law? Or?
Repeatedly, Judge. It took us 2 years to get a final judgment. We had hearings. I explicitly made the argument.
He actually ruled like 6 months later, but you guys fought over what the form of the judgment would be, I guess, for 2 more years.
That might be the reason why trial court judges should prepare their own judgments, because they do a better job of it than lawyers who find it difficult to set their advocate hat aside.
In some cases.
Judge, your letters, I never knew why you didn't just put the style and the done and ordered on them, because the letters that you turned out were practically final judgments.
But I didn't know how to do all that, Social Security numbers and all other stuff that had to be in there.
But the point I do want to make, Judge, is
Zero me in on, seems that the retroactive thing, that issue doesn't cause us much challenge. What are your other issues on appeal here, Mr. York?
That's it, isn't it?
I think the court should reverse the final judgment.
But that's the issue. That's the only mistake, correct?
That is the mistake. Well,
No, you also argued about guideline visitation, but that seems to be moot at this point, isn't it? They're over the age of 18.
it is kind of, because the kids now, I believe, almost 18, and
I think they're over the age of majority now, aren't they?
I didn't check this morning, Judge.
They have had a birthday today.
But, you should, this whole guidelines visitation, you should have an individual,
Okay,
every
if they're
family is
over the
different.
age of 18, would you agree that's moot?
I think I wrote a paragraph in my brief.
Okay.
The real point is that the specific statute requires.
Counsel, we wrote an opinion that said that,
Right.
and there's a statute that says it. I think that we get it.
I think
Yes,
Is
we're
there
on
anything else that you want to argue?
that. I think that's it.
No, sir.
I think you're right.
All right, thank you.
Yes, sir.
All right, have a
See you,
nice day.
Tom.
Have a good trip back.